I'm very pleased to welcome Nick Siddall QC onto the channel. Nick is an employment law barrister from Littleton Chambers. Nick is going to chat with me about the national minimum wage, and in particular, an important distinction between payments and deductions for determining workers' remuneration.
Matt, thank you very much for having me. Interesting case in which I was involved dealing with the national minimum wage, and it probably makes sense to start by discussing briefly what the national minimum wage is there to do. Well, unsurprisingly, it kind of does what it says on the tin. It's there to ensure that workers are paid a minimum amount per hour they work in order to avoid exploitation and ensure that they have a sufficient level of remuneration to amount to a living wage. It's got to be recognised in that context that it's a piece of social legislation. It's also got a protective purpose. The idea is to ensure the party with the greater bargaining power isn't in a position to abuse that power and force down wages to an unnaturally low level. The way the Act works, and I'll try and take this on as straightforward a basis as I can, the way the Act works is it looks at different types of workers, and for present purposes, let's just assume that it's hourly paid workers because that's relatively straightforward. And what happens is you look at the number of hours they work, you look at the number of the amount of money that they earn, you divide A by B, and if it's above the level of the national minimum wage, great. And if it's not, then there is a civil penalty and also potential criminal penalties. And also there's the naming and shaming scheme and everything of that nature, which employers are keen to avoid. Now, the way the national minimum wage regulations work is that most deductions or most payments to or deductions from the wages of a worker are treated as deductions which affect the calculation for the purposes of the national minimum wage. But there are some exceptions to that, and they're set out in Regulation 12 of the regulations. I won't deal with that in any detail because one of the complications of this particular area of the law is it's often A, counterintuitive, and B, very, very technical. But broadly, what Regulation 12 says, it draws a distinction between deductions on the one hand and payments on the other. And there are 5 classes of deductions or payments which are permissible under Regulation 12. But interestingly, the final category, Regulation 12(2)(e), only applies to payments. And its wording is payments as respects the purchase by the worker of goods or services from the employer, unless the purchase is made in order to comply with the requirements imposed by the employer in connection with the worker's employment. So very important then to recognise what's a deduction and what's a payment, because if you are in a circumstance where there's a purchase of goods or services, that's only permissible if it's a payment rather than a deduction. And that was the nub of the problem in the Middlesbrough case in which I was involved. So the circumstances were Middlesbrough Football Club had a number of matchday staff. And the matchday staff, if they wanted to, could purchase season tickets for their family members so that they could go and watch Middlesbrough play football. This was an entirely voluntary arrangement. The individual could go to the club and say, please, can I purchase a season ticket? They were allowed to purchase it over a period of time. They could say how many instalments that they were going to make the payment in. The only requirement was payment by the end of the season. And it was recorded in writing, completely consensual, and indeed to the employee's advantage. Because instead of incurring a credit charge on their credit card or having to pay all the money in one fell swoop, it was all deducted at source. But therein lay the difficulty. There was a deduction made. So what happened was that instead of the employee getting, let's say, £200 a week, they'd get 160 because a deduction was made from their wages of the agreed proportion of the cost of the season ticket. Now, that was a problem for the purposes of national minimum wage compliance. And the ET made a rather interesting decision, which the HMRC appealed. And on appeal, the question was, could you read the term payment to include, drawing an analogy with tax legislation, could you read it, payment, in a way which covered this situation? Namely, where the employee says, this is my money, but don't give it to me, keep it for yourself. The short answer to that question in the mind of the EAT was no, sadly. The conclusion which the EAT took was, you can't really draw an analogy with tax legislation because tax legislation serves a different purpose. Its purpose is to try and get in as much money for the government as possible and seek to avoid tax evasion in those circumstances. Whereas because this is protective social legislation, and where there had been a specific distinction drawn between the term payment and deduction, you couldn't construe payment to cover this scenario. It was a deduction. Because it was a deduction, it didn't fall within Regulation 12(2)E, and therefore it reduced wages for the purposes of national minimum wage compliance, and the effect of that was that the club had paid less than the relevant rate. Now, a second argument was advanced to try and avoid that outcome, which was on the basis of Regulation 12(2)B. Now, Regulation 12(2)B allows deductions or payments on account of an advance under an agreement for a loan or an advance of wages. Now, the agreement signed by the football club and the individual said, if you don't pay the money that you are obliged to at each occasion when you're obliged to pay it, you have to return the season ticket. And so the argument was run. Well, the effect of that was this properly understood was a loan arrangement. And consequently, because it was a deduction in accordance with a loan arrangement, it was lawful. The club came second on that one as well, because the view of the EAT was, look, this is talking about loans of money. It's not talking about the loan of something physical, even though the word loan could, on its dictionary definition, be read in that way. And the next point was made, well, realistically, there's no value whatsoever to the piece of plastic that was the season ticket anyway. It was simply a means of proving that the individual had the right to attend and view the football matches. So the effect is that the club, despite behaving entirely benevolently, behaving in a way which, if you looked at this in a vacuum, you would say, well, why on earth is HMRC in any way concerned about this entirely voluntary arrangement, which is concluded with the workers' consent? And the EAT's response to that is this. Well, Parliament chose to intervene in the area of the national minimum wage. Parliament has taken a policy choice to put in place protective legislation. The fact that this kind of arrangement as a matter of the common law is utterly unsurprising, utterly unobjectionable, isn't really addressing the point. The point is, it's a protective regime put in place to ensure workers aren't exploited, and an employer has to strictly comply with its provisions. And if an employer doesn't, they risk the finding of a breach of the national minimum wage and all the naming and shaming and penalties that flow from that. So the lesson to take from this particular decision is not, dare I say, don't be kind to your employees, but alternatively, always have a very clear view on the structure of the national minimum wage regulations and recognise that the consent of the individual and the absence of any complaint by them, because there was no complaint, it was HMRC had performed an investigation and come to this conclusion that there was a breach for themselves. So don't be lulled into a false sense of security by the fact that everybody's happy with this, nobody's going to raise any issue, because the enforcement and investigative powers of the HMRC are such that they can come in, they can conduct a review, and if they identify a national minimum wage breach, it's their obligation to seek to correct it. So recognise, in any circumstance where there is an arguable purchase by the worker of goods or services from the employer, you simply can't make a deduction. the employee has to receive the money in their hand and then give it back to the employer, because that demonstrates an example of real choice. Now, many people may say, well, what's the difference? And the answer is, realistically, there isn't any. But the difference is the protective social purpose of the legislation is served by the fact the employee has the money and chooses what to do with it. So that, I'd suggest, is the lesson to take from the HMRC case, and also on a slightly less expansive approach, recognise if you're dealing with the loan exemption, it can only be a loan of money, it can't be a loan of goods or chattels. So that's what I would suggest everyone should learn from this particular decision.
Nick, that's very helpful. That's very helpful. Yeah, it seems that if the football club had paid the money to the employees, and then they paid the instalments after having received the full amount, then that would have been okay, wouldn't it?
But indeed, that would have been absolutely fine. So if the way it had been done was that there was an organisational separation between wages and payment, so a requirement, for example, that the employee sets up a direct debit in favour of the employer, that would be fine. But it was the fact that the money never made it into the accounts of the individuals or into the pay packets of the individuals. It was deducted at source by the employer, and that's why it fell foul of the national minimum wage regulations.
That's helpful, and it's so important, for employers to get it right. As you say, there's the whole problem about naming and shaming, and also there are penalties which could be awarded against employers. So it really is important that people do get it right, and they don't follow the correct processes.
Indeed, hugely important. I mean, during the course of this appeal, the Treasury issued a direction that it wouldn't impose penalties and wouldn't name and shame in particular circumstances. And arguably, the facts of this case fell within the circumstances of the Treasury direction. So that was another point that was sought to be run on appeal. The argument was run, well, look, even the Treasury recognised we ought not to be punished here. Therefore, you ought to find that we don't fall within the scope of the regulations at all. And again, the club came second on that one, but it was an argument that was advanced. So yes, hugely important, because there's the negative reputational effect of a naming and shaming, and then there's the financial penalty, which is up to 200% of the value of the deductions.
And then it's up to, I think there's a maximum of £20,000 per worker. Is that right?
I think that's right, but it's per notice.
Yes.
So the possibility is, if you can serve, you can serve more than one notice, should HMRC so choose, and rack up more through that approach. And there was an authority, the name of which eludes me, which dealt with the question of whether you could have more than one notice dealing with the same employee, and the conclusion was yes, you could.
Thank you so much, Nick, for joining me on the channel and sharing your knowledge. I really appreciate it. I hope that you all found the video useful. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.